Response to number 72. Alleged failure to investigate plaintiff alleges that the Fort Collins Police Services, FCPS, and the Larimer County Sheriff's Office, LCSO, repeatedly declined meaningful investigation despite being provided dates, locations, and video evidence. That characterization omits critical context. Comma 1. Repeated probable cause determinations. Plaintiff publicly played voicemail messages left by law enforcement in which officers from both FCPS and LCSO expressly stated that they reviewed the complaints, they found no probable cause to arrest, the reported conduct did not meet criminal thresholds. A determination that no probable cause exists is not a refusal to investigate. It is the result of an investigation. Disagreement with that conclusion does not convert it into a constitutional violation. 2. Officers provided alternative remedies. Law enforcement further advised plaintiff to seek civil protection orders if the conduct continued, utilize court-based remedies, consider available mental health assistance resources. That guidance reflects engagement, not indifference. Police are not required to make arrests merely because a complainant insists one should occur. 3. Protection order proceedings. Undercut the systemic inaction theory. The record of protection order proceedings shows plaintiff initially applied for a protection order against Archbell. It was denied. Months later, plaintiff reapplied and obtained protection orders against Archbell and Thayer. His roommate, Shrub, applied at the same time. That request was denied. Thayer appealed and obtained reversal of the order. Plaintiff attended the appeal hearing and subsequently sought a new temporary restraining order. These outcomes demonstrate the courts were accessible, judicial officers evaluated the evidence, relief was granted in part, relief was denied or reversed where unsupported. That process is the opposite of a system refusing to act. Samisha 4. Subsequent enforcement action against plaintiff. Following the appeal hearing, plaintiff attempted to personally serve a new order by pursuing Thayer out of the courthouse parking lot, following him onto city streets, engaging in a vehicle pursuit, continuing the conduct in view of officers. Police conducted a traffic stop and issued plaintiff a harassment citation and summons. That sequence reflects law enforcement responding to observable conduct, not retaliatory enforcement for protected activity. 5. No constitutional right to compel arrest. There is no constitutional right to compel criminal charges, override probable cause determinations, force police to classify conduct as criminal rather than civil, require a specific investigative method. The Constitution protects access to courts. Plaintiff accessed the courts repeatedly and obtained relief at times. The allegations in number 72 omit law enforcement's documented probable cause determinations, ignore advice directing plaintiff to civil remedies, are contradicted by the actual history of protection order proceedings, do not establish denial of access to courts, do not establish deliberate indifference, do not demonstrate a constitutional violation. The record instead reflects discretionary law enforcement decisions, active judicial review, and court accessibility. That does not support municipal liability.